Good afternoon, everyone. I am very excited to have this conversation this afternoon about the topic of licensing paraprofessionals with our wonderful panelists from Oregon and California, two states that have reached conflicting results on the question of whether to license people other than lawyers to assist our neighbors with their legal problems who can't afford lawyers. And we are hoping to see what we can learn from both states' experiences. But before we get started, I have a few housekeeping items to take care of. I am Bridget McCormack. I'm the Chief Justice of the Michigan Supreme Court, but this is my debut as the Senior Strategist with the Penn Carey Law School's Future of the Profession Initiative, and I am very excited about this new role. I spent the day in Philadelphia yesterday with the team and meeting with students and faculty, and I'm really excited to be working with a dynamic group of leaders thinking about how to make our profession more equitable and more effective and more sustainable. I also want to give a shout out to a conference that we have planned, that the Future of the Profession Initiative has planned for November 3rd and 4th. Our 2030 conference is taking place in Philadelphia, and it is going to be a fantastic conference. The speakers are exciting. The theme is we are hoping to learn from our colleagues in the field of design to figure out how lawyers can use the principles of human-centered design to create healthier and more inclusive legal workplaces and more accessible legal services. The conference offers both live and virtual ticketing options. It's free for everybody in the Penn Carey law community. And we hope to see as many of you there in person or online. We're very excited about the conference. Okay, so a few housekeeping items about this webinar. If you have a question, we hope you will use the Q&A feature and let us know what that is. My goal is to finish the conversation by about 6:10, 6:15 and turn to your questions. So please put those in the Q&A as you have them. If you are seeking CLE credit for today's event, codes will be presented twice per hour. Write down those codes and enter them on your digital evaluation form once the event is over. The evaluation form is mandatory to get the CLE credits. You probably already know that. And the link to the form will be in the chat. The first passcode is landlord. I think those are my housekeeping items. So let me invite my panelists to turn on their cameras and their microphones, and let me introduce them first and then get this conversation started. Helen Hierschbiel has been the Chief Executive Officer of the Oregon State Bar since 2015. Before that, she served as the bar's General Counsel and Deputy General Counsel. She practiced with the law firm of Dunn, Carney, Allen, Higgins, and Tung in Oregon, and as a legal aid lawyer with DNA People's Legal Services on the lands of the Navajo Nation. She's a graduate of Amherst College and Lewis and Clark Law School, and we are delighted to have Helen to tell us about Oregon's experience. Jason Solomon is the Executive Director of the Stanford Center of the Legal Profession, where he works on issues at the intersection of legal services regulation and access to legal help. He also teaches at Stanford Law School, including a class called Reforming the Profession. He's worked as the Chief Legal Officer for the education nonprofit Summit Learning in the Clinton White House, and as counselor to the president of Harvard University. His research is about the civil justice system. We are grateful that Jason has agreed to join us to talk about California's thinking about this topic. And finally, my co-conspirator at the Penn Carey Future of the Profession Initiative, Jim Sandman, who is also a distinguished lecturer at the law school. You all probably have heard Jim speak very eloquently on the topic of access to justice in many different contexts. He's the president emeritus of the Legal Services Corporation, where he served as the actual president, not the emeritus president, from 2011 to 2020. He's a former member of the Closing the Justice Gap Working Group of the State Bar of California, and was the managing partner for Arnold and Porter in a prior career. So I am really delighted to have all of you here and really looking forward to learning from the three of you this afternoon. So welcome to all of you. I think I just want to start with a baseline factual overview to make sure our audience is kind of on the same page. And Jim, why don't I start with you? What are legal paraprofessionals or navigators or any other thing you want to call them? And why should we care about a legal system making room for that?
Thank you very much, Chief Justice McCormack, and thank you, Jason and Helen, for participating this afternoon. A licensed paraprofessional is a person, not a lawyer, who is regulated, licensed, and well-trained to provide legal assistance of a type that, without licensure, would be considered the unauthorized practice of law. The person might help a client identify the appropriate forms to fill out for their particular matter, help them fill out the forms, identify claims and defenses the person might have. They might represent the person in settlement negotiations or mediations. They might prepare the client for court appearances. The position is analogous to what we have in healthcare, with positions like physician's assistants and nurse practitioners and medical technicians, people who aren't doctors, but who nevertheless are licensed to provide certain kinds of healthcare. That's what the position is. Why does it matter? It matters because our current regulatory system leaves those people who can't afford a lawyer without access to anyone else to provide them with legal assistance. Anyone else who tries to provide legal assistance to them runs the risk in most states of being prosecuted for the crime of the unauthorized practice of law. The legal system today is overwhelmed with people who can't afford lawyers. Our courts have so many unrepresented litigants that there's a term now, lawyerless courts, that's been used to describe courts like housing courts where evictions occur, or many family courts. The National Center for State Courts estimates that in the United States today, in civil cases in state courts, where about 95% of all litigation, civil litigation occurs, both parties have lawyers in only 24% of the cases. In the 76% of cases where at least one party doesn't have a lawyer, the unrepresented party is often confronted with a case involving the most basic of human needs. I'm not talking about traffic ticket cases. I'm talking about cases that involve the roof over your head, shelter, protection from wrongful eviction or foreclosure, personal safety, a protection order against an abuser, family stability, child custody, child support, guardianships, adoptions. In 76% of civil cases in state courts, at least one party doesn't have a lawyer. It's also not appreciated that there's been a migration over time of lawyers away from serving individuals and towards serving businesses. In 1972, for example, 52.5% of all law firm revenue came from individuals, the majority. In 2017, the last year for which I've seen numbers, only 25.4% of law firm revenue was coming from individuals. So there are fewer lawyers serving real people out there today. Finally, it's important because the conventional interventions to address these problems, legal aid and pro bono, are simply not sufficient to address the magnitude of the problem that we have. Legal aid is woefully underfunded. The Legal Services Corporation, which is the country's largest funder of civil legal aid, released a report earlier this year that found that in the prior year, 92% of the civil legal needs of low-income people either got no help at all or inadequate help. Even if there were enough money to fund legal aid to serve everybody who is financially eligible, that's a tall order. Funding for the Legal Services Corporation, which comes from Congress, currently amounts to less than Americans spend every year on Halloween costumes for their pets. So, but even assuming funding were adequate, the income eligibility requirements for legal aid are so low that there are tens of millions of people above those thresholds who can't possibly afford a lawyer. Eligibility for funding supported by the Legal Services Corporation is limited to people with incomes at or below 125% of the federal poverty guideline. This year in 2022, that means for an individual, you can't make more than $16,988 and qualify for LSC-funded legal aid. Many legal aid organizations are able to use other funding to get their cutoff up to 200% of the federal poverty guideline, but that figure is only $27,180. You can well imagine that people making well more than that don't have any money to hire a lawyer. On pro bono, it's been estimated that every lawyer in the United States would have to do 180 hours of pro bono work every year just to provide 1 hour of help to the people who need assistance. So I don't want to be misheard. More funding for legal aid is critically important. That's a really good and important thing. More pro bono work is really good and really important. But we have 50 years of experience in trying to use those two tools to close the justice gap. We're nowhere near filling it. So we need to pursue other routes. That's why licensing paraprofessionals can make a difference.
Thanks, Jim. And thanks for sort of setting the table for us. Helen, who has cared in Oregon, and tell us the story of what that care has translated to. Tell us Oregon's story with this topic.
Thank you, Chief Justice McCormack, and thank you for inviting me to participate in this panel. So there are a lot of people who care in Oregon. We had a lot of engagement on this issue. Primary among those who care are the courts. The courts feel the burden of the unrepresented parties, the unrepresented litigants the most, and they see firsthand when representation goes wrong. So they want to see that people are represented, and they also want to make sure that the people who are representing individuals in court are competent to do so. So they care a lot. And we actually had 2 judges who led our committee for implementation. Judge Kirsten Thompson was the chair of the committee, and she was a family court judge, retired now, from Washington County, and also worked at Legal Aid for a number of years, and was a Spanish-speaking lawyer as well. So the courts care. Lawyers in Oregon care a lot. Their care is, some saw it as the new limited license as a threat to their own financial well-being, and a threat to, basically an existential threat, that somehow licensing paralegals would challenge and change their own license in some way, diminish the value of it. Members of the public care deeply about this. They obviously are the consumers of the legal services. And as Jim mentioned, there's an inadequate supply of a variety of legal help at a cost that they can afford. So we heard from a lot of members of the public on those issues. And finally, interestingly, we also heard from the legislature. Our legislature, state legislature, cares about it. And they care about it because they heard from their constituents and obviously want to make them happy. And so our state legislature followed our work very closely and frankly stood ready to do something if the bar did not.
Interesting. Okay. I'm going to have to chime in on some Michigan stakeholders, but first let me turn to California. I know we didn't even advertise Michigan in the title, but here we go. But Jason, tell us about California. Who was interested in this topic? I know a little bit about the working group and the work that was done. Who cared? Who started it, and what happened?
Yeah, so a lot of the stakeholders, of course, are the same as in Oregon, and I'm sure in most states. So just let me highlight a few either nuances or differences. So one thing, of course, is when Helen talks about, the courts and people who work in the courts, we're not only talking about judges, but we're talking also about people who work in the clerk's office and have to deal with self-represented litigants who submit things that aren't submitted right, and so they have to go back and forth with them. We're talking about people who work in the self-help center, and there was a great woman who works in the self-help center in the San Jose court who was on the paraprofessional program working group in California, who knows that she's doing everything she can to help these self-represented litigants, but knows that if there were only some people who were just trained up with a bit of experience, a bit of training, that they could really help the people even more. The other thing I'll say in terms of the stakeholders and who cared in California is, and just, sorry, let me just pause on one point that I hope we can get back to at some point about the judges and people that work in the courts. I know you've thought about this a lot and written about it, Chief Justice McCormack. And one thing that I think is worth us thinking about is how to make sure that the voices of the judges who deal with this problem every day and in the courts is really honored, no matter who the decision makers are, whether the decision makers are the legislatures or the state bar. I fear what ended up happening in California, which we can get to ultimately, the voices of the judges and the people that work in the courts was not really heard. And I think it's worth thinking about that, because I think that was a shame. The other thing I'll say about the stakeholders in California is the legal aid community, and I won't say too much because I know Jim Sandman has both experience and thoughts on this. The legal aid community in California lined up eventually, or at least those who were willing to make their voices heard, lined up against the proposal. We can talk a little bit about why, and I think the people who spoke out were largely based in Southern California, largely based in the LA area. A lot of them were really concerned about the phenomenon that's known as notario fraud. That is, people generally who are not lawyers, I think generally of Latinx or Mexican background particularly, who may be considered lawyers in their home countries, but here offer their services generally to immigrant communities. We don't have good data on how much notarios offer quality services that really help people, and how much they defraud people and take their money and don't help them much. But certainly legal aid lawyers who work in those communities are very concerned about the idea of more people who aren't lawyers, right? Paraprofessionals, more people who aren't lawyers, being empowered to help people. And there was concern that that would lead to more fraud and more ripping off people of moderate means. So I'll stop there in terms of the stakeholders and how they lined up in California.
Yeah, that's helpful. I mean, what's the response to that? Well, let me stick with you for 1 second, Jason. Well, you know, as somebody who would like to figure out how to address that concern, but also expand the pie, what if anything is the response to that concern?
Well, I think the concern, I think the response is essentially, look, why are people going to notarios? They're going to notarios because they can't afford lawyers, number one. Number two, these are people who have their same backgrounds, who they feel they can trust. And what if we actually licensed people? That is, we regulated people. We made sure that they were properly trained up. We subjected them to ongoing oversight, but we said you don't have to have 7 years of higher education to help people with basic legal services the way we do for nurse practitioners. And if you had people that were subject to training, regulation, and oversight, which notarios are not, wouldn't that be a better solution, more likely to catch any problems? And then we could steer them away from some of the sort of bad actors in the notario community. That I think is the basic response.
Yeah. Helen, let me come back to you for a minute. Tell me about the legal aid community's involvement in Oregon's paraprofessional program, or response to it, maybe.
Yeah, so the legal aid community in Oregon almost unanimously supported it. We have Legal Aid Services of Oregon. Their executive director wrote a letter in support, and the Oregon Law Center, their executive director wrote a letter in support. And then we had numerous lawyers from legal aid who were leaders in different offices around the state who also wrote letters in support. You know, it's when I saw that the California legal aid was not supportive, I was curious why. It seems like such an obvious, to me, solution that would assist with the work that legal aid is doing. And I think our legal aid community, I don't know how far you want me to go down this path, but
it's just curious that that stakeholder group lined up differently in each state, although I think Jason has given me a little more information that I don't think I understood before this conversation. So that makes some sense to me.
Yeah, I think there are a couple of reasons though in Oregon why they did line up with us. So first off, we provide some regulatory oversight over legal aid. So we have a long-standing connection with them and relationship with them. So when we first started talking about licensing paralegals, we started talking about it with them in really organic ways. And then when we developed an implementation committee, we invited them to the table. And there were some legal aid attorneys who were at the table with us who initially said, this is a terrible idea for all the reasons that Jason has said, and also it's second-class service. There were just, a lot of the familiar reasons why legal aid may be opposed. But as we started talking about it and talking about what the regulation would look like and the possibilities for increasing access, they changed their minds. The third thing I think that happened was that the Oregon State Bar was invited to attend the Western Region Summit Conference of Chief Justices and Conference of State Court Administrators in August of 2021. The court invited us and legal aid, so the two executive directors from the two main legal aid providers in Oregon, and Jim Sandman was there, and a number of other luminaries in this area who talked a lot about access to justice and the possibility of these regulatory changes working to improve access to justice. And it was very, and our chief justice wasn't there, but another justice of the Supreme Court was there as well as some of their staff. And while it was not news to me or our bar leaders, it was news to the court and news to legal aid, and very eye-opening. And the conference was an opportunity to develop a partnership plan to work on whatever regulatory initiative you wanted to, and we chose paralegal licensing. And so we walked away from that conference arm in arm, ready to carry the message that this was the right thing to do for Oregon.
So that was in the summer of 2021, and your program is now, I think, about 4 months in effect, if I'm correct about that.
Yeah, we actually, our court approved the rules for the new program at their meeting this last July. And but they will not be implemented, will not start the program until July of 2023, because we still have some work to do. We still have to develop the assessment tools that we'll use for licensing.
And can you just tell us briefly in what areas your rules, people will be licensed in, and how you thought about that?
Yeah, of course. So it's 2 areas, in the areas of landlord, tenant, and family law. And the reason for choosing those 2 areas is they're the 2 areas of highest need in Oregon. And there were some concerns expressed about, some people said we should expand it. Others said they were worried about it being expanded. And we decided that we weren't going to expand it right now, but that if we do expand it, we will use the same criteria for determining the areas of law. In other words, where is there high need that is not being met?
Jason, so less less successful story in California. I know that the working group recommended licensing paraprofessionals, and I believe there was support from judges at least and other stakeholders. But tell us a little bit about where California is now. Is the idea completely dead or dying a slow death? How do you think about it?
Yeah, I mean, look, I think we can see it as a glass somewhat full story. I think there's a very strong recommendation that came out of this paraprofessional working group from an array of stakeholders, judges, lawyers, people that work in courts, legal document assistants with broad support. I think the legislature made a determination that given this somewhat unique situation that's been going on with the State Bar of California for the last several years, that is, there's this backlog of discipline cases involving lawyers, and one or two particularly high profile and really bad stories involving lawyers stealing money from clients, essentially, that it didn't make sense at this time to start a whole new class of licensees that the State Bar of California would have to regulate. And so the legislature essentially said, and this is the chairs of the House and Senate Judiciary Committees, look, you guys need to get your house in order first in terms of the backlog of discipline cases, and you need to show that you can protect consumers before we open up this whole new class of licensees and say, okay, we're going to let these people who have less education, less training, et cetera, go ahead and serve clients. And so I'm cautiously optimistic that the amount of time they said was 2 years that they're going to put it on hold. I'm cautiously optimistic that in 2 years, given the continued need, we can move forward, but certainly there will still be challenges.
Jim, let me come back to you for a minute, because I know you were a member of the working group. Are there any other observations that you would make about the California process and the different ending it has had so far? I take the glass half full description. I like a glass half full, but still not quite full yet.
Yes, I was on a different working group, actually, the working group about creating a potential, what they call regulatory sandbox, not on the paraprofessional working group, but I did testify before the paraprofessional working group, and I'm familiar with what they did. I do think there were a couple of things at work. As Jason said, there was a local issue in California about a backlog of disciplinary cases and mishandling of disciplinary cases that opened the bar to an argument that you can't handle what you've got on your plate already. That was not an illegitimate concern. I do think that the notario situation had a lot to do with the opposition of the legal aid community, and the leaders of the judiciary committees in the California legislature really looked to the legal aid community for their views on the needs of the civil legal needs of low-income people. What I was at a loss to understand was why you would be concerned about licensed, regulated, trained paraprofessionals who would be completely different from unlicensed, unregulated notarios. If you have a good regulatory system, you have mechanisms in place to be sure that the paraprofessionals are not defrauding people. But what I heard from the legal aid community was a concern about a halo effect, a bleed, where the public might be confused about who's licensed and who's not. Once the word got out that you no longer need to be a lawyer, they might not be able to distinguish between the notario and the licensed paraprofessional. So there was that concern. There was also the concern that legal aid should hold out for more funding for more lawyers, that the answer is a lawyer for everybody. My own view is that's not going to happen in this century, and that for the people who are desperately in need today, that their choice is no help at all. The question is always compared to what? And I think help from a licensed, regulated, well-trained paraprofessional is way, way better than no help at all. Finally, there was a component of the bar that was actively opposed and lobbied, both within the working group and ultimately the legislature, the Consumer Lawyers Association, the plaintiffs' bar, who made an argument about protecting the public. Opposition to proposals like this, when it comes from lawyers, is always framed in terms of protecting the public. My response, and they said there's absolutely no evidence that this proposal will improve access to justice. There aren't any data. My response to that is there are plenty of data to show that the current regulatory system harms the public. The current regulatory system, which severely limits access to legal assistance provided only by licensed lawyers, leaves so many people with no help of any kind that in only 24% of civil cases in state courts do both parties have lawyers. There's been study after study that in state after state that shows how many civil legal needs of not only low income, but moderate income people are left unaddressed. There is not a single study, not one, that says that the current system is working well. So I think the evidence is all on the other side, that the current regulatory system isn't working to serve the public. The public owns the system, not lawyers. And I think there's plenty of evidence out there to show that the current system is harmful.
And I don't know the answer to this, but is there any data from other countries, and will there be data emerging from the few states that are starting licensed paraprofessional programs? I mean, yes, there's no data in California right now, but I guess there could be if we collected it for a little while. Do you know the state of the data more generally, Jim?
There is a licensed paralegal program in Ontario.
Yeah.
And my understanding is they have about 10,000 licensed paralegals in Ontario, and that the system works pretty well. I haven't heard of any harm to the public that's emerged from that system. It's been in place for some time, nor have I heard that it's had any significant negative impact on lawyers to the extent that that matters. In the other states that have licensed paraprofessionals, I think the proposals are still too new to have a lot of data about them. The oldest of them is the state of Washington, which created what they call the Limited License Legal Technician Program in 2012. But the Washington Supreme Court decided, I guess it was last year, to sunset that program as of 2023 because of the expense of administering it. They had very little uptake on the position, very few people signing up to become limited licensed legal technicians, which didn't surprise me at all because the barriers to entry they imposed were so high that they made the position very unattractive. Let's look at the name, for example, that they gave the position, limited licensed legal technician. I can't think of a title less likely to inspire confidence on the part of a consumer than a title like that. Doesn't even fit on a business card. What is that? And then they required something like 3,000 hours of supervised experience, 3 different exams, multiple educational requirements. It was very expensive, very time consuming, very unattractive. And it was costing them more than $1 million a year to administer a program that didn't have 50 participants in it. So that's why they killed it. But I think that outcome was foreseeable in the way the program was set up initially. In the states that have implemented licensed paraprofessional programs more recently, the barriers to entry are not nearly as high, and you don't have the titling problem that you had in Washington.
Let me just ask Helen a question about that in Oregon. What's the process for somebody to become a licensed paralegal in Oregon? And I'm sure you all studied Washington when you thought about how to set up a successful program. So what does it look like? What will make it successful in your estimation?
Yes, we did look at the Washington LLT program, and in fact, Jason came to speak to our board about what went wrong in Washington and recommendations for what Oregon could do differently. And barriers to entry was a big part of it. And so, for example, are the educational requirements in Oregon are very broad. Basically anything from a paralegal's associate's degree and above will satisfy the education requirements. There are 1,500 hours of supervised practice that are required, 500 of which have to be in landlord-tenant law, if that's the area of choice, or 750 in family law, if that's the area of choice. And we got a lot of negative feedback about the small number of hours and the educational components. But where we're focusing our efforts are really on the assessment piece. So the committee developed a very detailed scope of practice that the licensed paralegals would be able to engage in. And now we are developing the assessment tools by which we will measure their competence. And our committee also did not want to rely on a bar exam type way of measuring competence. You might be familiar with the work that Oregon is doing right now around alternatives to the bar exam for lawyers. There's a strong feeling in our state that the bar exam is not equitable. And so the assessment method will be a portfolio of work that might include an exam, but not a bar exam, an exam or exams on particular topics, but nothing like the bar exam. So those are the basic requirements for entry. There is also a specific 20-hour educational component, but 20 hours is not school hours, it's 20 actual hours in particular areas of law, including ethics, mental health, substantive areas of law, procedure, things like that. And that we anticipate that the bar will pull that program together, although we invited community colleges to do the same.
I want to get from each of you your thoughts on how you would advise a state, looking to head in the direction Oregon has gone in. But first, I want to take one question from the Q&A. This is from Len Reiser. Whenever I try to explain this issue, I go with the analogy that Jim began with, the health system and its array of licenses and specializations. It seems to me that this system is widely accepted and generally makes sense to people, but somehow the analogy often doesn't seem to be as persuasive as I would have expected. What is it about law that provokes such a different reaction, or at least a higher level of inertia or resistance? And that question resonates with me, Len. Jason, do you have any thoughts about that? Why do people resist the idea of different professionals being able to provide different services within the legal industry when they don't resist it in medicine?
Yeah, first of all, I agree. It's a great question, an important thing for us for folks like us to dig into. I think we know intuitively, because we've all experienced basic medical issues, that getting a flu shot you can get from a nurse more easily than a surgeon. Or if you have a cold, you don't need to see a doctor either, and you can get basic things. I don't know that we have in our head exactly, and I think it's maybe on many of us to help articulate what the equivalent is in the law. So, for example, off the top of my head, I would say, eviction cases. So a lot of what we're talking about in the housing area is we're talking about eviction or what's known as unlawful detainer cases. Is it really that hard to represent someone and essentially negotiate an agreement that basically says, hey, can we have a few more weeks to move out and we'll pay you this amount of money, but you won't get all your money? That, I think, my again, somewhat limited understanding, I'm not a housing expert, is that this is basically what we're talking about. So that we're not talking about complicated issues of law, complicated applications of law to fact in most cases. So I think it's worth thinking about what are those sort of limited but basic legal services that people might understand are not that difficult to provide.
Thank you.
Can
Jim,
I-
do you have any thoughts about this question? I wonder if there's, sorry, go ahead.
I do. My own experience is the reaction depends on who you're talking to. If you're talking to a lawyer, you tend to get the skepticism, and their skepticism is based on their view that law is complicated and that many legal problems are multi-dimensional. They're not as simple as they might look. And they have legitimate concerns about having people who aren't trained in the entirety of the law to deal with a particular portion of it. When you talk to people who aren't lawyers, I don't get that reaction. Most Americans don't realize that you don't have a right to a lawyer in a civil case. That's where they're starting from. They think you do have a right to a lawyer. Most Americans get their knowledge of the legal system from TV shows, most of which are about the criminal justice system. They could give you a pretty good approximation of a Miranda warning, including that part about having a right to a lawyer and one being appointed to represent you if you can't afford one, with no idea that there is no such right in a civil case. I mean, I've talked to PhD members of Mensa who don't realize there's no right to a lawyer in a civil case, who don't realize you can lose your home, have your children taken away from you, need a protection order against an abuser, and have no right to a lawyer. When you talk to lay people, non-lawyers, about the situation and draw the analogy to healthcare, the reaction I get is, of course. So I only get the skepticism from lawyers, and it's based on their concern that law is different and law is complicated.
And I think that is borne out in some of the work states have done around surveys on this topic. I think when states have asked the public how they feel about the offering these services, their reaction is often different from lawyers answering the same set of questions. So which might be part of someone's advice if you're advising a state that wants to figure out how to do this and do it well. That might be part of what you're thinking about. But let me hear from each of you. Helen, what would you say to the Arkansas Chief Justice if he shows up at your office and says, "How do I go about setting up a paraprofessional program in Arkansas?" What's the answer?
I think you really need to understand the specific politics of your particular state and set up a robust process for engaging all of the stakeholders that may voice opposition to and support for the program. And by robust process, I mean coming up with multiple ways of seeking feedback around the proposal, engaging stakeholders in developing the proposal, even if they don't agree, and making sure that the public's voice is heard. You know, in Oregon, our process really started in June of 2017. It was a long time ago when we first started talking about paralegal licensing, and it took our board that it came from a recommendation from a Futures Task Force report, the Oregon State Bar Futures Task Force report. And our board shopped it among members of the bar for 2 years before deciding to actually establish an implementation committee. They actually tried at one point to establish another exploration committee. And when we sought volunteers, the volunteers said, no, this is a lot of work to do this. So you either decide that you're going to support it or you don't support it and let's stop talking about it. We've been talking about it long enough. So the board, our board was courageous really in making that decision to establish an implementation committee at the very beginning. We were very deliberate in our choice of members for the committee, and it was small. We had 2 judges. We were supposed to have 2 members of the public, but we could only get 1 to participate. We had 2 family law lawyers, 2 landlord-tenant lawyers, and 2 paralegals. One of the paralegals was a court facilitator as well. Those were the voting members, and they were all committed to developing a program and were in favor of a program. And then we had a huge advisory group that was basically anybody else who wanted to participate. And we specifically invited legal aid. We invited our Trial Lawyers Association was very opposed to it. And we said, come join us, sit in on our meetings, tell us what you don't like. Anybody and everybody we could think of, we invited to the table. And so our meetings were large. It took us a long time. It was messy. We did the same, we had some of the same conversations over and over again. And as we got feedback, we incorporated that feedback into the report. There were several times during the process that we wanted the board to make a decision to adopt the report, and we saw that it was not ready, and so we slowed it down. So the first time was in November of 2021. We hoped that the board would adopt the report of the, we called it the PLIC, the Paraprofessional Licensing Implementation Committee, and there were people who were going to be there speaking against it. Jim came and spoke in favor of it. It was very important and impactful that he did that. And in the end, we just asked the board to approve it for public comment. So we backed off and we gave it more time. And then we did another round of testimony before our board in February. And again, just kind of let people say their piece. And we specifically, we were worried that the public wasn't being heard. And so we engaged a consultant to do a survey of members of the public, in particular, the communities that we were trying to target, low and moderate income communities, from traditionally underrepresented communities. And that report came back, not surprisingly, 97% of the individuals were in favor of paralegal licensing, 97%.
Wow.
And that was powerful for our board to see. Like I said before, we had a number of different mechanisms for people to express support. Oftentimes, there's just an email link, and lawyers love to write. And so lawyers dominate the space. And in fact, we had that mechanism, and that's exactly what happened. So a really robust process is incredibly important. And every time we got a comment of something, some argument that we were worried would be the hat that would take, or the hook that would take this down, we tried to respond. So that our board asked, well, Washington got rid of it. Why is this any good? Jason came and spoke about how we could do it better and still make it successful and why it was important. We just kept responding. They talked about budget, so we brought forth a budget. They, every time they started nitpicking on the rules, we said, okay, we'll draft all the rules so you can see them. So robust process.
Sounds like robust process and lots of patience in responding to every single concern, right? Actually, not giving any concern short shrift. You probably convinced a lot of people along the way, it sounds like, with that kind of patience.
Yeah, I mean, the one other thing that I would say about that's critical is our court was supportive.
Yeah.
We engaged with them early and often. We gave them quarterly updates about what we were doing. We said, are we on the right track? If not, please tell us so that we don't spend another 6 months working on this. They actually provided feedback as well. And in the end, they, our board, our process, it goes to our board first, and our board voted on it 14-2 in favor. The court was unanimous in favor.
Yeah. Jason, California is anomalous in a lot of ways, but the bar's relationship to the legislature is pretty anomalous. I don't know any other state that has that same kind of relationship, but you've been following this issue everywhere, not just in California. Do you have anything to add to Helen's advice to a state starting out a process that, you know, wants to think about this?
Sure. I would say two things about expectations and two things about what I'll call calibration. So in terms of expectations, I think it's important to be realistic in terms of the expectations about where this kind of model is going to really help. So this kind of paraprofessional model, in my view, and I think based on the evidence, works best where you have an area of law where people can pay something, right? Where you're not talking about the lowest income people, but you're talking about a lot of need of moderate income or middle income folks, teachers, nurses, grocery store workers, who, if it's important enough to them, can pay something. Family law is the best example of this. Because it's important to them, they have a bit of money that they're willing to pay. And I'll contrast it a bit, with apologies to Helen, to housing, where I think one needs to be cautious, and there's some evidence out of Ontario that gives you reason to be cautious about, if you're worried about all the people who are in court and facing evictions, we want to be cautious about how many of those folks are actually going to be willing and able to pay for the services of a paraprofessional. That's one set of expectations. The other thing that's important to be clear about on expectation, this relates to the Washington experience, is how long it's going to take for the program to become self-sustaining and whether it will ever become self-sustaining. So a lot of the way that this was sold in Washington to the Bar Association was, oh, lawyers' fees aren't going to go to this. You know, we'll need some startup costs, but eventually the fees that paraprofessionals will pay for the sort of regulatory apparatus. But that never happened in Washington. And so I think, you know, one needs to be realistic about both how long it will take and whether one will ever get there. You could just say, look, the bar is a regulatory agency about our justice system. Part of the money just has to go to access to justice. And that's just how it is. Expectations. Two quick things about calibration, and this relates to what folks talked about Washington and the barriers to entry in Washington. It's important to, for quality assurance and other reasons, have enough education and training up front that people are assured that the paraprofessionals can do the job. But if you raise the barriers too high, as they did in Washington, you aren't going to get enough paraprofessionals in the program, and therefore you're not really going to address your access to justice program. The related point on calibration is in terms of the number of practice areas. So as Helen alluded to, some people want to do more practice areas. Some people say, well, let's just start with housing and family law or whatever and see how it goes. I understand both instincts. The calibration point is, if you're a paraprofessional in an urban area, you can make a living just doing family law, right? So Seattle, King County from Washington, you got a bunch of paraprofessionals who are making a good living just doing family law, which was all that was allowed in Washington. If you're in a more rural area, and as everyone knows, the more rural or otherwise less populous areas is where some of the most serious access to justice problems are. People aren't going to be able to make a living unless they can do a variety of practice areas, right? Unless they can be more generalists, the equivalent of the small town lawyer. And so that's an important thing to think about as you think about the number of practice areas. I'll stop there. Thanks.
Thank you. Helpful. I want to see what Jim has to add to this. But first, let me tell everybody that the second CLE word is Oregon. Oregon is the second CLE word. And then I have one more question in the Q&A, but I'll get to that after. Jim, do you have anything to add to Helen and Jason's very helpful advice to states who might want to start down this path?
I have 4 quick takeaways. First, the active involvement, support, and leadership of the highest court in the state is really, really important. Where these processes have worked best, the court has been actively involved. Second, an inclusive process is important. That's Helen's point about the involvement of particularly legal aid from the get-go as full partners in the discussion there. That made a big difference in Oregon. I wouldn't limit it to them, obviously, but an inclusive process is important. Third, look to what other states have done. You don't need to reinvent the wheel here. The conference that Helen mentioned, that the Conference of Chief Justices put on, I think was helpful because of the learning that was shared there by Utah and Arizona. The National Center for State Courts has great resources on what other states has done, as does the Institute for the Advancement of the American Legal System at the University of Denver Law School. And finally, maybe most important, you need to find a way to get active, real feedback from the public on this. The public is the biggest stakeholder here, not lawyers. The conventional processes for seeking input on lawyer regulatory issues, notice and comment procedures don't work for the public. They typically involve posting things on court and bar websites. Real people are not lurking around court and bar websites looking for things to comment on. And when you use the conventional routes, the predictable happens. You hear overwhelmingly from lawyers. In California, for example, when they sought comment on the paraprofessional proposal, 73% of the comments came from attorneys, 73% of the comments from individuals came from attorneys, and 90% of them were opposed. Of the non-attorneys who commented, a much smaller percentage, 78% were in support. That phenomenon has been repeated in every state that has addressed this issue. Lawyers opposed by supermajorities, the public supports by supermajorities. The trick is to get meaningful public support. And you've got models out there, like what Oregon did, very thoughtful outreach. Arizona is a great model. In Arizona, they did focus groups, they did a survey of the public, they did town hall meetings. They did real outreach because they recognized the importance of meaningful public participation and the inadequacy of the traditional tools for generating it in a context like this. We need to hear from the public about this. They're the ones who own the system.
Thank you. We have one more question in the Q&A, and I'm not sure who can answer it, so I'm just going to throw it out, and whoever has the answer can start speaking. Couldn't the concerns about paralegal competence or performance be resolved by mandatory malpractice insurance? I just don't know that market. Do Helen or Jason, do you have any thoughts about the market for malpractice insurance for paraprofessionals?
Well, I can speak to it from the Oregon experience. Oregon is the only state that has mandatory malpractice insurance that's provided by basically a captured fund. Our professional liability fund provides malpractice insurance for lawyers in Oregon. And the licensed paralegal program in Oregon requires that paralegals have insurance through the professional liability fund. So that was an item that a lot of people commented on and that we included in the program. Excellent.
Well, I really want to thank Helen and Jason and Jim. I learned a lot. I hope everyone else did as well. Please click on the link for the Law 2030 conference. We're pretty excited about a lot of the conversations we're going to be having in 2 weeks in Philadelphia. But like we said, you can join us online. We would love to see you and hear from you and collaborate with you. Thanks again to the panelists and to everybody else for tuning in today.